Okay. All right. Well, sorry, good timing. As we go into our next section, we're going to talk about the financial parts of family law. And then we're going to conclude with our final piece where we talk about equitable distribution. But right now, I'm going to talk about the general financials of how that impacts the everyday part of family law, and start with child support. And it is so crazy to deal with custody as much as we do, and then suddenly you change the rules pretty significantly when it comes to child support. The first thing that you have to do in child support is you have to establish paternity. You have to establish who that person is. I have a child support enforcement program basics that I have as hyperlinked to this meeting, and kind of goes through what North Carolina considers as being the entire level of child support and what you have to go through. Basically, if a child already has a legally responsible father due to marriage of the child's mother or prior determination of paternity establishment, it's not appropriate, except as allowed under certain circumstances. And you can see what those circumstances are. Over the time of my practice, it's been radically changed. North Carolina will accept an order to show paternity. I am not going to go through a lengthy discussion about the differences between legitimation and paternity, and what is usually just splitting hairs in terms of what issues are there. Generally speaking, in a case, I would just say for purposes of this training, you need to know who the father is first, and that needs to be established. There are various ways to establish it. In North Carolina, primarily, it is just finding an order which does, in fact, establish that person as being the father of the child. We could really go down some rabbit holes in terms of what that's going to look like. But a couple of things I would say is a birth certificate is great evidence as to it, but is not necessarily controlling if the parties are not married. If the parties were married, there is controlling, and you can kind of stiff arm other fathers from saying that they are the father if there has been a marriage. And then if that person is not the father, there is a affidavit of non-parentage that the child support 4D office might be involved in. Just before we go down that road, I wanted to say that if you're new to family law, you're going to hear the word 4D a lot. And the word 4D comes from the, oh shoot, did I lose Caitlin? Okay. Somebody can text Caitlin back. Oh, there she is. Okay. In the 4D is the part of the federal law, which all states had to adopt in order to get federal funding or Medicaid funding. And basically that is the federal government says, look, if we're going to pay Medicaid for children, then we need to be able to reimburse from the father or from the other party, the non-custodial parent. So they established offices in North Carolina and South Carolina. That is an office in every county. So we have 100 different, well, not quite 100, it's like 85 agencies that are out there enforcing child support in North Carolina. Similar number in South Carolina, proportional number that are all out there collecting child support. Now, when you're talking about 4D, they will help you a lot in establishing paternity. They'll know what's going on. But when it comes to child support, generally speaking, they are graded on getting 100% of child support. That means that for them, it doesn't necessarily make sense to go after every dime and dollar in a child support one, because they're graded on what percentage of that they can collect. What they really want is a moderate amount of child support, but that they get every month. That's the best way for them to grade themselves. They don't want somebody paying more than they can afford, because that reduces their number. That may not be the same interest your client has. Your client might be, I want to get as much child support as I'm actually owed. I'm going to look in every nook, cranny, or whatever that might be. So do not just get into the habit of saying at the end of your child custody cases, well, I'll just send them over to 4D. Try to establish and get child support. It's not complicated. We can do this, and it's something I think it's really important to do. Number one, a separation agreement is controlling for purposes of child support. You can see that in Jackson v. Jackson. That is the Pataki case in North Carolina that says that if the two parties agree to what child support is, the child support will generally create a rebuttable presumption as to that the amount that they agreed on for child support. A separation agreement is a contract between the parties, and the court is without power to modify it except to provide for adequate support for minor children and with mutual consent of the parties thereto where rights of third parties have not intervened. So you come up with a separation agreement, it's binding, and it's not easily modifiable by the court. If there is where the parties to a separation agreement upon the amount for child support and maintenance of their children, there is a presumption in the absence of evidence to the contrary, the amount mutually agreed upon is controlling. Sorry, let me start to see. So the Pataki case is that in a Pataki case where you have a separation agreement where the parties have already come up with an amount, and in Pataki that was 0, by the way, the actual case. Then you want to modify it. You need to show the actual needs at the time of the hearing as compared to the time of the separation agreement, and the needs would make a finding that the application of guidelines would be inappropriate. So you want to get into the presumption and trying to rebut the presumption. I put in that entire amount of Pataki so you can see if the parties agreed on child support and now they're disagreeing. Pataki shows you how to overcome the presumption or the Pataki presumption in the case. That's if there's not a separation agreement, then you have to come up with child support, and that is just guideline support. So you get the appropriate worksheet. If it's worksheet A, that means that the father or the non-custodial parent has less than 1/3 of the time. If the non-custodial parent has over 1/3 of the time, that's going to be worksheet B. And it essentially goes by nights, but there's a little case caveat to that I'll talk about in just a moment. And then C, there is a worksheet C, and that is if mom has one child and dad has one child, then you're on worksheet C. That does come up from time to time. The court may consider support from third parties, but is not required to. So one of the first things you do is determine what that party's income is. And there are some cases that actually kind of drag in other one, but it is important that you find out what somebody's income is. Their income is a regularly occurring numbers. A regular occurring number can be a bonus. They can get a bonus, they get it regularly, then it becomes part of their regular income. If they regularly get overtime, that's fine, that's part of their income. If they regularly receive some kind of benefit like clothing allowance, school allowance, whatever that might be, well, that becomes part of their income. So you want to see anything that can happen and is repeatable is their present income. And it's important to be able to call it the present income. Okay, I have some cases I think are worth talking about. Biggs, private school expenses to meet the educational needs of the children are extraordinary expenses under the child support guidelines. So if there's private school, that's extraordinary expense. You want to show that both the parties agreed to private school when they were together, then you can continue into private school and call it extraordinary expense. The Cole case from 2002, when the parties have consented to a temporary order at a later date, a subsequent order on the merits of permanent is the initial order of child support and should refer to the guidelines for the amount that should be effective from the filing of the complaint. even if the amount and date are different than the amount and date of temporary order, and even if the permanent order creates an automatic arrearage, though the father has been paying under the terms of the temporary order. So you want to go back and trace it back to the date of the complaint, and you can use that, and then you can subtract the money that has actually been paid. So a temporary order doesn't necessarily change what the child support might be. Lasecki, in 2016, the trial court erred in ordering specific performance of the support obligations contained in the separation agreement based on obligor's earning capacity rather than his actual present income, without a finding that the defendant was acting in bad faith. So you want to say, like, okay, you cannot impute income unless that person is acting in bad faith, and that applied to even a separation agreement. The Cumberland County case in 2016, father's basic allowance for housing and military salary should have been included as income for purposes of determining child support. So you want to look at the things that are outside to be able to add to it. And then finally, the CABS case, if participating children expenses is not a true sharing of overall expenses, worksheet B should not be used. In this case, the mom was working third shift and dropping the kid off at dad's house. So dad had all the overnights. And the court said, well, that's not fair for worksheet B. She's making all these payments, but not getting credit for it. So even though the child was staying with dad, it was able to overcome and get a worksheet A because mom was actually providing that number. So that's just one of those things where I'd say be careful about worksheet B. It may not apply completely. Next is the deviation in child support. I've noticed that the courts here are allowing a lot of deviation. It's not designed to do that. This is what you have to do to deviate from child support. You have to determine the presumptive amount under the guidelines. So you got to run your child support guidelines first. Next, you got to hear reasonable needs and the child and ability to pay of the parents, and then determine whether the guideline amount would not meet or exceed the reasonable needs of the child, considering the relative ability of the parent to provide support, or would otherwise be unjust or inappropriate, and then make written findings of fact to allow meaningful appellate review. So you got to go through that whole process in order to deviate. Now, one of the reasons you could deviate is if one parent is paying 100% of the health insurance. So if you have one parent working, the other parent's not working, and that parent that is working is paying 100% of the health care, you can see that it can become a pretty high amount of child support. And the courts will say, like, wait a second, we will deviate for that. That's actually in the guidelines themselves. It'll say, well, that's one reason to deviate. Because if a parent is paying, let's say $600 a month for the child, and they're the only worker, they're paying $600 a month in that way, and they're paying child support, it might be that they end up paying a good bit more. And the court will deviate in a situation like that. Just got to find out what's a fair amount, what actually works. I think that I've noticed that the judges are cracking down on imputing income. You're supposed to only impute income if it's bad faith. There is some cases that talk about naive indifference, where in that case, the naive indifference case, there was a nurse. She had a husband. She left her husband to go to marry the doctor. Is like the classic case. She went and married the doctor, and the doctor said, well, you're now married to me. You don't need to work anymore. So she stopped working. The court said, no, you don't get to benefit of not working because it's naive indifference for you to reduce your child support to zero because you're not working when you're only not working because of your new husband. The new husband's income doesn't qualify as part of it, but what she would have been making does. So, you have to go back and do some analysis in order to come up with that child support. But I think it's not rocket science. You can go through and do these cases and do a pretty good job of making sure that you get things covered. Child support is, primarily the easiest way to advise our clients is what I tell them is child support is going to be for one child, 18% of your income. And for every child thereafter is 3% more. So 18% of your gross income, if you're just trying to do a really quick thing for your client, if you're in a consult, just say, well, it's 8% of your gross income. If there's 2 children, 21%, 3 children, 24%. And that is super rough. So don't necessarily, but gives you sort of an idea about it. Because when you have a person who's making $100,000 and you tell them, say, look, for your one child, you're going to have to do about $1,500 a month. It's going to, and you got to pay insurance on top of that. They're going to be like kind of flipping out because they're not going to be like, I only make 100,000 and I got to give, $1,500 a month to her or vice versa. They're going to have some trouble with that. And they need to hear it early on and say like, well, if it's 2 kids, it's going to be more like 1,700. So gives them sort of an idea. Also, it goes in reverse. Like when one child graduates or becomes 18, they think that their child support is going to be in half because there was 2 kids. Now there's 1. It should be half. No, it's not. It's going to go from 21% to 18%. Usually not enough to do because they've probably gained more than 3% income since that order was done. And they're probably more apt to be better off just to let it alone and keep paying that child support until all children are gone. Does that make sense? Okay. Patrick, you have anything to say about child support?
Yeah, just on that last thing you said, something sprung to mind. You got multiple kids subject of a child support order. One of those kids ages out, that child support obligation remains until a court order says something different. So even if there are 2 kids, at the time the order's entered, 2 kids, one kid is 2 years old, the other is 10. Well, fast forward, oldest child is 19. The youngest child is whatever the math is. I forget my hypothetical. Anyway, just because that one kid has now aged out, you don't get to split your child support obligation. I've seen people do this and then it bites them in the ass. Because once there is a child support order, there's a child support order. That's it. If you want that number to be changed, you have to ask the court.
How do you do that?
Patrick, you're muted.
Did you hear anything I said?
Yeah, we heard all of it till the end. What did you do?
I don't know.
You miracle muted. Okay, that's fine.
Well,
But yeah, we got most.
Well, anyway, a child support order is a child support order. It's their obligation remains. Even if one kid ages out, the complete obligation remains until a court says something different. Now you can go in and ask for it to be changed, but if you don't, and then you change it yourself, you're just setting yourself up for an arrears judgment. So it seems counterintuitive, right? You could have one kid who's 20 something and still have one that is under 18. And you're like, why would I have to be paying the same amount that I was when they were both kids? It's true, but you got to go in and ask the court to change it.
And like I was saying, be careful about doing it because that
Correct.
is usually just a 3% difference. And if your client income has increased by 3% or more, they may very well end up making a motion to reduce because the child has gotten over 18 and find that their child support is raised because of the percentages that impact it.
And another thing on child support is I've seen people do this, and likewise, it bites them in the ass. They will have an order that's, consent orders, especially. Here's the number. And then the parties themselves will work. A year later, they'll be like, hey, let's change it pursuant to the guidelines. And then the parties start operating under that, right? And then they'll change it again in another year. 6 months time. Hey, I hurt my back. I'm going to be out for a little while. Let's change it. I saw some people do this. Doesn't matter. Somebody changed their mind a lot later, sometime later, and said, oh, I didn't realize that I could still stick you with all this, even though that I said it was okay for us to reduce it. So I'm going to do that. And yeah, the case law is pretty clear on child support orders and the obligations that stem from those. They are there. You can't escape them. So even in that scenario I'm talking about, somebody's going to get stuck with big arrearages, and then that can't go away, right? So just don't let people mess around with child support. If you want it to be changed, you need a court order, period. Another thing on child support, I'll say, I don't know, Brian, if this is baked in, if you're going to do a modification of child support, or if we're talking about that now. But again, for me, when I started practicing family law, it was counterintuitive. I said, okay, here's our formula. Use the worksheet. Here are all the things that the state of North Carolina says that we are to consider when coming up with this figure. Well, if one of those things changes, that is not in and of itself per se a basis for a modification. It seemed counterintuitive to me anyway. For example, I had a client who had a baby on the way. At the time he entered into a consent child support order. And sorry, I'm talking slow. I think this is the COVID brain, but had a baby on the way, and the baby came, and he wanted to modify. And I was like, yeah, that makes sense. And then actually pull out a little bit of law. And there's case law that says having a baby, having another child is not reason enough, is not in and of itself a basis, is not a substantial change. I guess the state of North Carolina just assumes that once you start doing it, you'll always keep doing it. And and you're gonna have more kids. It's natural, and it's something that you want. It's something that you freely take responsibility for. So interesting little bit. Just thought it was worth sharing, just so, because it will pop up in y'all's practices, I'm sure. This has popped up in mine more than once since then, and not in and of itself a basis to modify a child support order.
Yeah, no doubt. Modification of child support is a heavy motivator for people to come here. The question is it going to be worth it for their time to spend the money on us to reduce their child support? a lot of times the answer is going to be no. And I think that because of that, makes it difficult for us in family law to kind of navigate those modification of child support cases that goes along with it. So, you just want to be able to advise your client appropriately. Tell them, okay, it's going to be all of your income from every source, all of their income from every source, maybe impute some of that. How many children do they have prior to? And then, what are the healthcare costs? Maybe the child daycare costs, and then extraordinary expenses. And generally, that's going to be how are they expensive as compared to another child of their age? If they're in, that's the way I describe it, to be able to kind of get to what I believe is child support number in those cases. Okay, all right. I went
one more. I just thought, and this is just springing to mind. Extraordinary expense can also, I don't remember if it's the guidelines that say this or if I saw it in case law somewhere, but can also include travel expense for exchanges. If you got cases where somebody's up in New York and somebody's down here, it actually falls within extraordinary expense. So
Yeah,
don't
one's
forget that one.
In the guidelines. It makes a big difference. A lot of times that especially in a time like this where I don't know what IRS guidelines are going to be per mile, but it's probably going to be around 75 cents or more. And if that's the case, I mean, suddenly it can get into the several hundreds of dollars to do exchanges, and that should be counted on both sides for that matter. Okay, all right. I'll move on, but we can pick up some of these other issues. Post-separation support alimony is next. Just got confirmation from Divorce 123 that they're going to be doing individual ones to kind of get us all on board. So hopefully everybody will be on board on that. So you have to determine, get that financial affidavit correct and get all the information there. But I always advise in a post-separation support case, an alimony case, that you do 3 separate affidavits. You do your client's financial affidavit, and then you have your client do their financial affidavit. Your client probably knows how much money they make. And a lot of times they'll be like, look, he makes a lot of money under the table, or they do get money some other way, or whatever it may be. Do a financial affidavit for the other side. And then you should do a third one of all of the factors. You should have for them the 16 factors of alimony and the related ones for post-separation support. And you should have a place for them to have an affidavit that says these things are going on. And it may be tax issues. It may be that that one party is paying an extraordinary amount of money for the children. There are about 16 or 7. I think I can't remember. Anyway, there are a lot of factors in alimony, and you want a separate, is it 16?
16, yeah.
Yeah, 16. But I think that like the last one's like a catch-all.
Yeah.
So it's kind of like an endless number. So you just want an affidavit that shows each one of those things that's there. So 3 affidavits, post-separation support. Why? Because some judges only are going to make a decision based on the affidavits, and that would be enough in order to make that determination. So a few cases that I throw in: Evans case, at a hearing of post-separation support, the judge shall consider the acts of marital misconduct by the dependent spouse occurring prior to or on the date of separation in deciding whether to award the post-separation support and deciding the amount of post-separation support. That includes sexual acts and indignities rendering the condition of the other spouse intolerable. Remember, if one side brings up marital misconduct of the dependent spouse, then their marital misconduct can come up as well, but not until that happens. Rove case in 1998, post-separation support is not appealable. So whatever that decision is, the way you appeal it is to put the alimony on. You will not find court appeals cases on post-separation support. Alimony is not bound by an award of post-separation support or even the findings. So it doesn't matter what happened in post-separation support. Alimony is its own separate trial. The fatto is post-separation support doesn't end at divorce. If a post-separation support, it only ends at an award of alimony, or it's terminated in some other way, like death of one of the spouses. So if you have a good post-separation support order, You don't have to do an alimony. You just let it keep rolling. That post-separation support can continue on. The Squires case in 06, post-separation support can be entered on a brief examination of the party's needs and assets and can be done by affidavits only. So there is case law that backs that up, and judges will do it on affidavit only. So you should do all 3 affidavits because you may not get a chance to do it otherwise. In alimony itself, you must plead in the statute that the plaintiff is a dependent spouse and defendant is a supporting spouse, and alimony is equitable under all factors. To get attorney's fees, you got to follow Hudson, and we have a whole little area on attorney's fees in just a moment. Number 1, the spouse is entitled to relief and demanded. The spouse is a dependent spouse, and dependent spouse did not have sufficient means whereon to subsist under the prosecution of the suit. That's how you get the attorney's fees. Alimony case law there's a lot of alimony case law. It's one of the biggest areas of case law in family law. Earp case in 81 says condemnation does not have to be pled as an affirmative defense where the plaintiff pleadings allege cohabitation subsequent to defendant's misconduct. A party does not have to deplete their estate and assets before getting alimony. So in other words, you can get alimony even if you have plenty of assets. It's not a situation where they have to be in debt or in need or something like that. They can have money. It's about their circumstances and customized living. Court must make findings of fact concerning the length of alimony, not just the amount. The Rue Court said the court can consider the parties had a history of savings, but cannot speculate as to how the ED part of the case is going to go. So just because your client has money in savings doesn't mean that person cannot receive alimony. I've heard that kind of argument in court too. Well, she's got all this money in savings. She inherited this money or whatever it's going to be. Does not matter. Alimony, we have good case law to be able to back that up. The Gray in 2006, the court can find that a defendant is not exercising reasonable capacity to earn by accepting furlough or not considering to relocate. So they have a duty to try to keep up the jobs that they have. A spouse cannot be reduced to poverty in order to comply with an alimony decree. That's in 2008. 2015, Court of Appeals held that findings of a divorce judgment went beyond the facts needed to address the limited issue for it and were not therefore law of the case and binding upon the judge at the alimony hearing. All the trial court is required to find for divorce is the parties have been separated for at least 1 year before the action is filed. Because a specific date of separation is not required, any such finding made in the divorce judgment is not binding on the parties or the court. Now, that's a pretty shocking result. That's a 2015 case. So if a separation date is in a divorce, it's not binding on your alimony claim if you're able to show that the alimony, you should have been come earlier or something like that, and the divorce is entered. So don't just give up because the court found it in divorce. The Carpenter case in 2016, equitable distribution should be determined before alimony if you can get that done. Why? Because what the parties get under equitable distribution may have an impact about alimony. And most importantly, it's a business is what that normally comes up to is if, let's say, the husband has a business and wife was a stay-at-home mother, well, she may be entitled to half the business in equitable distribution. You can't get half the business and half the income. That's double dipping. So you're supposed to be able to determine alimony after you finish, you get your equitable distribution. Post-separation support is for that pre-part of it. Okay, so I know that's a lot of information to go into, but I think all of that's important in making this determination. Any questions on alimony or child support? Okay, all right, let's take about a 5-minute break and then we'll pick up equitable distribution and then what I call the other issues of divorce. So I got 3:30, 3:35.